Hello, I'm Susan Schoenfeld, a senior legal editor at BLR's Human Resources and Employment Law Publications. This is the third video in a series that answers questions we've received regarding medical certification under the Family and Medical Leave Act, or FMLA. Medical certification is a topic of many tough questions we receive from HR managers through our Ask the Expert service. One aggravated leave manager recently asked us, an employee has an intermittent leave to care for a child's serious health condition. Can we require the employee to provide us with a note from the child's physician for each missed day due to the child's serious health condition? Well, the answer to this question is probably not. Once the need for FMLA intermittent leave has been certified, an employer should not request additional medical documentation for absences because this may be viewed by the DOL as a request for medical recertification. As a result, FMLA regulations only allow an employer to seek recertification after 30 days, unless specific exceptions apply, which we will discuss in a few minutes. Medical certification for a particular condition is in effect for the duration of leave as specified on the certification itself. So if the medical certification indicates that the minimum duration of the condition is more than 30 days, an employer must wait until that minimum duration expires before requesting a recertification. And that, again, is unless one of the specific exceptions applies. In all cases, an employer may request a recertification of a medical condition every 6 months in connection with an absence by the employee. Therefore, even if the medical certification indicates that the employee will need intermittent or reduced schedule leave for a period in excess of 6 months, for example, a lifetime condition, the employer would be permitted to request recertification every 6 months in connection with an absence. So, what are these exceptions to the 30-day certification rule? An employer may request recertification in less than 30 days if any of the 3 following circumstances exist. First, if the employee requests an extension of leave beyond that which is stated in the certification. Second, if circumstances described by the previous certification have changed significantly. For example, if the duration or the frequency of the absence has changed, or the nature or severity of the illness or complications has changed. Finally, if the employer receives information that casts doubt upon the employee's stated reason for the absence or the continuing validity of the certification, the employer may ask for recertification in less than the 30-day allowable window. Remember, though, that the employer may provide the healthcare provider with a record of the employee's absence pattern and ask the healthcare provider if the need for leave is consistent with such a pattern. This is very helpful for employers needing to show a certifying physician that the employee's pattern of absences does not quite match up with what the doctor's anticipated absences for the condition would be. Note also that because intermittent leave may be necessary due to episodic flare-ups and unpredictable absences, if the medical certification states that leave may be necessary for such unplanned and unscheduled flare-ups, the employer may not require documentation of absences or additional certification unless one of the exceptions we just discussed applies. In our first video in this series on FMLA medical certification, we addressed the question of whether obtaining medical certification is always necessary for leave. In our second video, we addressed a scenario where an employee was out on workers' compensation leave and refused to get medical certification for accompanying FMLA leave. I hope that the information in these videos will be useful in your HR practice and in administering FMLA and medical certification in the future. Thank you.